Hello friends, Namaskaram. In today's class, I will discuss an important topic concerning sanction order. As we know that sanction order is sine qua non to prosecute a public servant under Prevention of Corruption Act. For this, we have to rely on section 19. But apart from that, there might be cases where the concerned public servant is the member of civil services concerned with union or state. And inter alia, the order of dismissal or removal is passed by the authority subordinate to the authority by whom the public servant or the government servant is appointed. But the primary question arises whether the said scenario is against law or not. If yes, whether the said scenario could affect section 19 subclause 1 of PC Act or not. So first of all, we have to answer query number 1, for which we have to study Article 311 of Constitution of India, that says no person, please be noted, who is member of civil services of the union or the state or hold a civil post under center or state shall be dismissed or removed by the authority subordinate to that by which he was appointed. So I think that we get the answer in affirmative in favor of defense. So basically, if the authority which is going to dismiss or remove you from your charge must not be subordinate to the authority by whom you are appointed. But said protocol will be applicable only when you are member of civil services concerned with union or state, or you are holding a civil post under center or state. In routine way, the said protocol would not be applicable because the specific categories are entirely assigned in the article itself. Now the second question arises, what will be the impact of said protocol on section 19 subclause 1 of PC Act? To understand the said criteria, we have to study the judgment of Honorable Kerala High Court, which is quite important on that point. First of all, we have to note down the basic credentials. Judgment title is S. Attakoya versus CBI. Judgment date is 19th of August 2025. It is pronounced by Honorable Kerala High Court. In that case, the sanction order was challenged and ultimately discharge petition was filed by the accused on ground that sanction order is defective, and that's why the continuance of proceeding is nothing but abuse of process. But the trial court had rejected the petition. Finally, a revision petition was submitted as per the protocol of section 438, section 442 of BNSS. I want to clarify that whenever a revision petition is submitted, in that scenario, the fight is to be done on the legal point. If you are going to fight on the factual score, in that scenario, we could not be succeeded. So in the present case at hand, the story of prosecution was that there are multiple accused who has criminal conspiracy, in consequence of which the officials of government entirely abused their official functions and power to provide undue benefit to the concerned private individuals. They approved the contract at the exorbitant rates in lieu of bribe, which is regularly paid by the private individuals. Finally, all the accused persons were charge sheeted as per section 11, 14, section 13, subclause 1, subclause A, section 13, subclause 1, subclause D of PC Act, read with section 420 of IPC and 120B of IPC. But I want to clarify that it has become the daily grind of CBI to impose section of criminal conspiracy on ground that accused persons are conspired and that's why they had committed the crime. But in the routine way, the protocol of criminal conspiracy could not be applied. In ample judgments, Honorable Supreme Court approved the said view. Because criminal conspiracy comes into motion when two or more than two persons agree with the common object to do or cause to be done an illegal act, an act which is not illegal by illegal means, such an agreement is considered as a criminal conspiracy. So when they agree to do the illegal act and apart from that they think in the same way, in that scenario the criminal conspiracy could be attributed, but in the routine way, it could not be attributed. To sustain the point of conspiracy, we are having Section 10 of Indian Evidence Act or Section 8 of Bharatiya Sakshya Adhiniyam. That might be quite helpful to find out whether there is conspiracy or not. So the prime attack of defense was that the authority who accorded the sanction is not competent, and that's why Section 19 subclause 1 of PC Act is violated. The prime attack is that inter alia there is violation of Article 311 of Constitution of India, because it is the prime submission of defense that the concerned accused person are the member of civil services concerned with the union, and they are appointed by President of India. But sanction is given by the authority subordinate to President of India, and by the virtue of delegation, Article 311 of Constitution of India could not be infringed. The prime attack of CBI was that the contention raised by accused is totally baseless, because as per rule number 8 of Central Civil Services Classification, Control and Appeal Rules 1965, delegation is permissible, and that's why the authority to whom the power is delegated is totally competent. But it is observed by the Honorable Court. The said rule cannot bypass the mandate of Constitution, and that's why the entire sanction and the proceeding subsequent thereto is nothing but abuse of process. Finally, the impugn order is set aside. But the key point is that whenever there is a case against you under Prevention of Corruption Act, and case is under Section 7 or 11 or 13 or 15 of PC Act, and the authority who accorded sanction is not competent, in that scenario, Section 19 subclause 1 of PC Act violates, and the concerned state could not take shelter of Section 19 subclause 4 of PC Act. So whenever you are the member of a civil service, of union or state, or holding a civil post under center or state, and inter alia you are removed by the authority who is subordinate to the authority by whom you are appointed, and inter alia that authority accorded sanction, in that scenario sanction order would be illegal, would violate Article 311 and Section 19 subclause 1. So in that scenario you could challenge sanction order and could secure the discharge or acquittal, whichever is applicable. So I think that I'm totally able to enlighten all of you about the subject. See you in the next video. Till then, Jai Hind, Jai Bharat.